Afternoon, everyone. Thank you so much for joining us today. My name is Becca Cotto. I am the Director of Community Engagement with YWCA Delaware, and I have some amazing guests here with us today. Elizabeth Darling, who is with Edward Jones. We also have Jacqueline, who is with, I'm going to just say DCRAC, and she can tell you what that means.
I started my career as an educator and a professional musician. Actually, I spent almost a decade doing that. Changed careers, moved over to finance in 2022. My office is in Wilmington, Delaware. I put a big emphasis on making sure that women are well informed about their finances, making sure that people have goals when it comes to their money. And I find when people can have a holistic conversation about money, about wealth, about family, about the unexpected, it really helps people to stay more centered around their investment goals. And then my office is on Silverside Road. I'm just about 8 minutes from downtown Wilmington, exit 9 off 95. And I'm really excited to have Jacqueline here. We've actually done this presentation a few times. It's very important to both of us, but Jacqueline, why don't you introduce yourself as well and kind of what you do?
Thank you. Hi, everyone. I'm happy to be here today to share a bit about estate planning. And as Lizzie mentioned, we've done this presentation before together, and usually everyone leaves really excited to start thinking about this topic, even though it's not always what you're at top of mind, but we'll make it fun today. I'm the Deputy Director at DCRAC, the Delaware Community Reinvestment Action Council, where we have a nonprofit law firm and we assist families with estate planning every day. So the most important thing to know is that it's for everyone. It's not just something that people with a lot of money need to do. We really all should have a will. We should all have a healthcare directive, and we should all have a power of attorney. So that's what we'll get into.
Yeah. Yes, and I'll tell just a very brief, meaningful story about that I always share in relation to this. Part of why this presentation is so important to me is because right before I became a financial advisor, my husband is an only child, and his mother passed away relatively unexpectedly in 2022. And at the time, she was in the hospital. She was in a coma. And, there were certain things that were not put in place that made things immensely difficult. She did not have a healthcare directive. So she had to be resuscitated multiple times. They broke her ribs. Luckily, she was able to come to enough to make the decision for herself to not be resuscitated again. But if she had not, because there was no healthcare directive in place, we were kind of powerless to move forward. And she was in some ways powerless in terms of directing how she wanted her last days to be because she didn't have a healthcare directive. My father-in-law, her husband, was not able to access a lot of money that he needed at that time because she had him listed as a beneficiary on an account that he probably should have been a joint owner on. And because of that, we had to borrow money from someone during a difficult time because there was no financial power of attorney or durable power of attorney. So there's just, it's so hard to lose someone, right? And it's so much harder when things aren't put in place to make things easy for you to just grieve, right? When you have to deal with all these other things. There's always going to be paperwork, but having someone that you've already met, whether it be a financial professional or an estate attorney, someone who's an advocate for you, that you've already established that relationship when something traumatic happens, can make all the difference. And I tell people, really, it's the kindest and most generous thing you can do for the people you love is create an estate plan. So with that in mind, we're going to move forward. We're going to hold questions till the end. You can feel free to put them in the chat, but we will answer them at the end just because there's a lot of people on and things can get kind of specific, and hopefully we can answer them on the way. All right, so very quickly, I always give a little bit of an introduction about what I do on the finance side. So if anybody were to ever meet with me, these are the things we kind of talk about. I have this 5-step plan. whether you have $1 or $1 million. We're going to talk about the same thing. When you talk about investing money, I always start with where are you currently at and where do you want to be? Because really, investing should be about the goals that you have, not the other way around. You don't invest the money and hope to reach your goals. You start with the goals and then you invest it in that way. And then from there, can I get there? How do I get there? That's where some of the investment talk comes in. And then the partnership. So that's step 5. So if you were to ever form a relationship with me as a financial professional, I like to say you're with me for life. I might be steering the ship, but we're in a professional relationship. Hopefully for the next 25 to 30 years. I'm checking in year to year. I want to see how you're doing. I always want to know when things change. When you reach that critical time towards retirement, we meet more often. It's just really nice to be able to build those relationships with people. So that's a little bit about what I do. So in terms of a portfolio, we're going to talk a lot today about preparing for the unexpected. But I like to tell people you plan for the expected, you prepare for the unexpected, and then you position your financial portfolio for both. All right, I'm going to skip forward because we have a lot to talk about here. Okay, so we have some estate goals. So we're going to talk a little bit about asset transfer and incapacity protections. These are estate goals that people have. Guardians for minors or dependents, charitable intent, tax planning, business succession. These can all be goals that people have for their estate. And when it comes to why do you need to get your estate in place, why do you need to visit an estate attorney? All of these things and more, right? But a lot of times, and I think Jacqueline will talk a little more about this, deciding what's right for you when it comes to an estate plan is not always easy. It's something that I think takes a little bit more expertise because there are lots of different documents out there. There are lots of different options. There are things that everyone should have, but beyond that, everybody's going to kind of have a specific estate plan according to you, your family, the goals that you have. All right, so we're going to start with the account registration. You can kind of see here a lot of other things we're going to cover as we move forward. We'll talk about a will. We'll briefly talk about a trust and kind of the differences between them. I always get asked about that. A little bit on taxes because everybody wants to know whether the government's going to take their money after they die. So we'll talk a little bit about that and probate. A little bit about life insurance as well as it relates to estates, and then something called transfer on death. Okay, so account registration and beneficiary designation. So this is an important one. I want to talk briefly about this, but I'm going to open it up to Jacqueline first about what are some maybe common misconceptions in regards to account registration and maybe as it connects to wills.
Yeah, so when you have financial accounts, you typically have the option to name a beneficiary on your accounts. Well, actually, take a step back. The first thing is to understand whether you own an account jointly or if you own it solely. Sometimes, in a case with a married couple, they may think that they are both named as joint owners on an account, when in reality, only one person is the owner. Sometimes there's an authorized user. Sometimes one spouse is named only as a beneficiary. So understanding how accounts are titled is really important in step 1, because in the event that there is a jointly owned account and one person passes away, typically the survivor would then continue to own that account and there would be no interruption in use and authority over the account. If you have a solely owned account and the owner passes away, then we need to look to see who is the named beneficiary or designee for transfer on death. And then that person may be able to access the account, but there is going to be a time where the account may be inaccessible while that's going through a process. So understanding how they're owned and then how the beneficiaries are designated is important, because if there is an account that lacks a beneficiary designation or it's only solely owned, if there's nothing in place for that, then that account needs to pass through the will, which is through the probate process. And that process will take even more time. So I usually ask clients if there's an account and there is an expectation that those funds would be used for the funeral, for example, then you want to have a way that it can be accessed quickly as opposed to accessed only once the estate was opened and then the funds are transferred to the estate and then they can be used, which could take several weeks or months. So those are the really important things to understand so that you can plan accordingly.
Yeah, absolutely. One thing that I really emphasize when I talk about account registration and things like that, normally within any type of relationship, there is one person who tends to be more dominant with money, or someone who has more information about accounts. You know, I don't like to get into a gender conversation, but there's a lot of women on here, right? So a lot of times I have women tell me, my husband handles all that. And that's fine. There's nothing wrong with having one person handle, in my house, I handle all the finances, right? But my husband knows how to access all of our accounts, and he knows where our life insurance documents are, and he knows how much it is. Do you know where your paperwork is? This is what I often ask people. Tell me where your paperwork is, and tell me if you know how to access it, right? It doesn't matter if one person is more in control, especially if you have children, but regardless, you need to know where your important documents are. God forbid something happens. So having that discussion with your spouse, whether it's, do we have a financial advisor? What do our investments look like, in terms of retirement? And who would I call if something went wrong? If you don't already have an established relationship with someone who meets with both of you. And also making sure things are registered correctly. There are very unfortunate situations that happen where, someone might have accounts go to a former spouse or someone unintended. And if you have the wrong person designated on that, legally, most of the time hands are tied. You might be relying on that former spouse to hopefully do the right thing or something else, but they don't necessarily have to. So making sure that your beneficiaries are up to date. I also recommend that you just go through your documents every couple of years and make sure that your will is updated. I know we'll talk about this when we get to the will, how often we think we should update that. But yes, making sure your account registrations are all in order, that you know when things are joint, when things are individual. It makes all of the difference. Okay, this is a common misconception. Accounts that designate a beneficiary are not controlled by a will. So, as Jacqueline was saying, if you don't have a beneficiary on these accounts, they might go through the probate process with a will, which is a slower process. But if you have beneficiaries on an account, regardless of what you've put in the will, the beneficiary designation is what matters when it comes to the estate plan. They will look at that. It also is a very easy way to transfer money. It's a very easy and efficient way after you pass. So life insurance policies and annuities, retirement accounts, and other investments and bank accounts. A lot of bank accounts allow you to put beneficiaries on your account, which is something that they may not always mention to you, but I always like to have my clients ask, hey, can I add beneficiaries on my bank account? It makes things a lot easier. Anything else on that, Jacqueline, before we move on to the will side of things?
No.
Okay, perfect. All right, so now we're going to actually talk about what is a will. Arguably maybe one of the most important estate documents you're going to create, if not the most important, one that everyone should have. One common misconception that I think we should address right at the beginning of this too is that only wealthy people need an estate plan. That's simply not true. Everyone needs an estate plan, even if it's a simple one. Everyone needs to have something in place for their loved ones or whoever is going to be handling their property of any kind after they pass away, whether they have children. If you have children, it's especially important. A lot of times when you're a younger married couple, it's not something that you want to think about even with young children, but it's very important to have that estate plan if you have young children. So everyone should have one. Now that we've dispelled that rumor, you don't have to be wealthy to have it. All right. So what is a will? Okay. So what specifically is a will? If you don't have a will, let's talk about that. If you don't have a will when you die, all the assets without designated beneficiaries will pass. And I always pronounce this word wrong. Is it intestacy, Jacqueline, or intestacy? I always say it
Yep.
wrong. Intestacy?
It passes through intestate succession or through the
Okay.
intestacy statute. So it's both.
Okay, good. I got it right. Either way. So essentially what this means is that assets will be distributed according to the laws of your state, which most of us here I think are Delaware. So the laws of Delaware. So regardless of your wishes, I always tell people if you don't have an estate plan, if you haven't created one, there is one in place. It's just the state of Delaware's. And you may not like it. And it may be very complicated for your loved one. And then we've got the probate of these assets when there is a will. It's called a testate probate estate. So to make sure your assets are distributed according to your wishes, this is the part where you should work with someone like Jacqueline. You know, they can help you implement the decisions on issues such as whether property should be directly transferred to your beneficiaries or held in a trust. They can help you understand tax consequences of decisions. And then, you know, the will is also the place where you can indicate a guardian for your dependents. If you have minors or children with special needs, you'll probably want to name a legal guardian for them. And then one of the first things you want to do is name an executor of your will as well and designate a trustee. And we'll talk a bit about that in the future if we're talking about trust. But most simply, a will determines who gets what assets when you die, and it's a way for you to establish your last wishes. All right, so I will turn it over to Jacqueline to talk a little bit more just about the specifics that you might find in wills, why it's important to work with an estate attorney when you create your will.
Yeah. So first, what is probate? Okay, probate is really the process that's set up to make sure that when someone passes away, all of their assets are transferred to the next person, whether through the will or through the statute, and also to make sure that any outstanding debts and legal claims against the person who passed away are settled if possible. So probate is the process that takes care of that. And probate is a process that happens whether you have a will or if you don't have a will. So it's really that process of getting everything to the right people. When we do estate planning, usually the goal is to avoid probate by having beneficiaries designated, maybe placing real estate in a trust if necessary. Otherwise, when things go through probate, it's not a bad process, but it does take some time. The typical probate process takes a year. And if your beneficiaries or your loved ones have needs that need to be met on a sooner timeline, then we look at alternative ways to make sure that they are taken care of. So that's probate in a nutshell. I think it gets a negative connotation because people think that it only happens if you didn't do any planning or
Right.
it's always a mess, and it's not always a mess. And a lot of
Right.
times families are able to go through it on their own, working with the Register of Wills office. But it's just important to understand what will go through probate or what doesn't need to go through probate so that you can help prepare your loved ones, especially in cases if you have a mortgage, if you have young kids, if you have, the rest of the family will continue to live in the house and they need to be able to receive that ownership quickly to maintain their lifestyle. So those are the things we talk about to figure out if probate and how your assets should flow. A will in Delaware needs to be signed by two witnesses. It needs to be notarized. We also sign a self-proving affidavit at the time of signing a will. And this way, when the will is presented, it's clear that it's a valid will and your wishes are clear in the will. So The law looks to the intent of the testator, the person making the will, and if it's unclear, there could be more time involved in the probate process to determine what was the intent or if there's conflicting information. So it's important to get that document done correctly. And then, of course, as Lizzie mentioned, to revisit and make sure that it still meets your needs as life changes, as people grow up, as new children are born. All of those things may change what you need to have in your documents.
Yeah,
So the
absolutely.
role of the executor or the personal representative, these are the people that are named to take care of your wishes in your will, or if you don't have a will, the statute looks to your family tree and they appoint the next person in line to take care of everything. The executor's job is really as a fiduciary over the estate to make sure that all of the assets are gathered, all of the bills are paid that need to be paid from those funds, any outstanding tax returns are filed. And then once all of the accounting is approved, then they can distribute the assets to the beneficiaries.
Yeah, and this is the part of the conversation where I normally emphasize that it is so much better to have transparency about this type of thing before you pass than to leave it to your family to kind of find out by surprise afterwards. Choosing an executor, essentially, you really want to just choose someone that you trust, right? That's most important. But for some people with multiple children or other things, maybe it's an important discussion that you want to have as a group, right? Um, I grew up in a family that didn't talk a whole lot about money, growing up, and I help now facilitate some of those conversations with people about money that can be uncomfortable. Because it's just so important to have transparency, not only transparency around how you want your will to be executed, but also, I think, on the other side, from the people that are on the receiving end, maybe of some of your assets and other things. It's amazing what the types of things that can be uncovered, and also the kind of relief it can bring, if you're able to have full transparency around an estate plan. So, as much as possible, I really advocate for that. And I do help facilitate those conversations too, because like I said, I know that money is not always an easy thing to talk about, but it's a very important one. It's an important discussion to have around this topic. Okay, so we talked probate. Thank you, Jacqueline, for discussing that. Yes, I often hear people say, I want to completely avoid probate, and not realizing that, like you said, probate's not necessarily always a dirty word. It just has to do with, a judge determining validity in relation to a will. But it can be lengthy, and that's why we try to take, any opportunity we can to avoid things going through it if possible. Okay, so the other thing that's important to remember is that a will is only activated after you pass, right? There are certain documents that you can actually utilize while you're living to talk about different things. And then once you pass, it goes to the will. So these are the main ones we're going to just briefly touch on. So durable power of attorney. So this enables you to identify and empower a person to make financial decisions on your behalf while you are living. Very, very important. It remains intact even if you are incapacitated. However, this power only applies to assets you individually own. So property or assets within a trust are still managed by a trustee, but it is going to allow someone to be able to make financial decisions on your behalf if you become incapacitated. Something, that no one ever wants to think about, but is, like I said, I gave that example of my mother-in-law, is very important, especially if you have a lot of your assets tied up in one place. When we talk about a healthcare power of attorney, it can sometimes also be called an advanced healthcare directive, healthcare proxy. Every state actually has different specific guidelines on what you can utilize in relation to a healthcare directive. Jacqueline can speak a little bit more about that, about Delaware in just a minute. But it does essentially the same thing as the durable power of attorney, but for medical rather than financial decisions. And then, a living will can be pretty similar to a healthcare directive, but it lets you legally indicate your wishes with respect to life prolonging procedures. in case you become unable to communicate them clearly. So Jacqueline, why don't you can expand as much as you want or as little on any of these and kind of the importance of them.
Yeah. So when it comes to the durable power of attorney, one thing that I hear often, and I think it's important for everyone on this Zoom to know, that a power of attorney is no longer valid once the principal passes away. So once that person who's given the authority for someone else to act on their behalf as their power of attorney, once they pass away, that document is no longer valid. The authority no longer exists. So from a practical perspective, what that means is if I am the power of attorney for my mom and I'm managing her bank account that is solely owned by her throughout her lifetime, I'm taking care of her. On the day she passes, I no longer have access to that account if I'm not the beneficiary or joint owner or, on there otherwise.
Yeah.
So what that means is that I cannot then use that account to write a check for her funeral or for her medical bills. And that information is very important because, as I mentioned before, if there is a need to have those funds used for the purpose of a funeral, for example, then you want to do some additional planning to make sure that there won't be anything stopping your family from accessing the account. So that's really important because the other thing I hear a lot is that I have a power of attorney, so I don't need a will. And again, because of what I just explained, that's simply not the case because your will would say where the account would go, who has authority after you pass away. That power of attorney would no longer be in effect once you die. So that's why that's really important to have both of them. And then as far in Delaware, the standard document we use is called the Advanced Healthcare Directive, and it's actually the healthcare power of attorney plus the living will together in one document. So it goes over the administrative authorities for your healthcare agent to make, the basic medical decisions, get your doctor in place, get insurance information, help fill out new patient paperwork, all of that. And then you have your living will piece, which are your end of life decisions, whether you would want to receive treatment to prolong your life, or if you want to say, don't prolong my life, or you want your agent to decide. All of that goes into the healthcare directive here in Delaware. So all of these documents really work together. Even on the medical side, I mentioned your healthcare agent would be the one to help manage your medical care, like setting up doctor's appointments for you. But for example, if there was an issue with your insurance company and the insurance company said, we're not paying for XYZ treatment and there's something that needs to be worked out, most likely they're going to need to talk to your durable power of attorney who is appointed there as your agent. So when you think about who you're going to appoint for these different jobs, if you are thinking of different people, you do want to consider how they will be able to interact and work together to assist you.
Perfect. Perfect. Yeah. Really important documents. Like we talked about at the beginning, not every document is for everyone and their specific estate plan, but everyone should have these documents and everyone should have a will. And these are not the types of things that I will just, not to offend anyone, but you don't want to go onto Google and just type in create a will and do Google make a will. There's nothing wrong with getting the beginning started with that, but it's not the kind of thing you want to mess around with without talking to a legal professional, because there are lots of things that need to be put in place to make sure all of these documents are certified and don't have to be validated and don't create a lot of complexity. So now we'll move on. I want to very briefly touch on trust. And then we're going to talk about a couple of other things, life insurance being one, and something called transfer on death really quickly before we take questions. These are kind of covering the documents everyone should have. I'm going to talk briefly about trust because everyone always has questions kind of about what trusts are and what they can be used for. So we'll answer a few questions related to that, and then we'll go from there. So the first thing I will say about trust is that there are many, many different types. I recently went through a wealth management certification designation, and I swear like 80% of what I was memorizing and looking at for my exams were all the different trusts and all the different reasons people establish them. And it's not necessarily always for the same reason. Like people might think it's always for protection of assets, or it's always for this. So actually trusts have many, many different purposes. And it's often for people that have specific needs. So we'll talk about that. It does allow you to be able to more specifically designate how your assets are managed. So, but very loosely, what is a trust? So it's a legal arrangement in which an individual gives control of property to a person or an institution, otherwise known as the trustee, for the benefit of designated individuals or organizations. So they are legal documents that allow assets to be transferred into a trust and then managed by a person called a trustee on behalf of whoever the beneficiaries are within that trust. Okay, so why do people establish trusts? What can a trust do? So if anyone here has a child with special needs, trusts actually become immensely important because of the way money has to be handled for children with special needs. There are certain things that make it really essential to talk to an estate attorney about a trust if you have a child with special needs. Limiting a child's access to inheritance until a certain age. You know, there are certain situations where people may not want their child or their beneficiary to inherit all of their money at once, right? Trusts allow you within certain guidelines to be able to be more specific about how your funds are allocated or your property. And then, of course, taxes. That's the thing we hear about a lot for high net worth, but also sometimes for other reasons, for property reasons, for other things. They do help reduce estate taxes. So very briefly, because some of you might be a trustee, so what are the trustee's responsibilities, right? So establish and implement an investment strategy, record keeping, providing accounting to beneficiaries, paying trust expenses, and making distributions according to the terms of a trust. So when you're establishing a trust, you can appoint a family member, a friend, a legal or tax professional. You know, for some types of trust, you can even serve as the trustee during your lifetime. You know, the most common trusts that people often hear about are revocable versus irrevocable trusts. And we won't touch too much on this, but Jacqueline, why don't you very briefly and generally describe the difference between revocable and irrevocable trusts?
So a revocable trust is a type of trust where you, as the settlor, the person creating the trust, retain control over your lifetime as long as you have capacity to make changes to the trust. And that's what makes it revocable, where you can make changes, you can move assets in and out of the trust, you can change beneficiary designations, you can change successor trustee designations. You retain full control as long as you're able to. With an irrevocable trust, you, as the settlor creating the trust, you will name a third-party trustee. It doesn't have to be an institution, but it can be you. It might be your child or a nephew or niece or just some other party to manage the assets. And once that trust is written and signed, you don't have the authority to easily make changes. Now, it's irrevocable. There may be ways to make changes. So, yes, legally, it may be in the realm of possibility. However, it's not going to be easy. And so making the determination of which trust is right for you is very important from the beginning so that you're not setting something up just to have to be undone down the road, and also thinking about the purpose of the trust. Often a revocable trust is used really to make sure that if you were to pass away or if you were to lose capacity, your assets would quickly transfer quickly and efficiently without too much work, without having to pass through probate to your next beneficiaries that you've named. On the other side, the irrevocable trust is often used to shield your assets from creditors or in Medicaid planning or in cases where you need to legally separate yourself from your assets.
Yeah. And Jacqueline, this is backtracking a little bit, but I realize it's an important thing I get asked often, and we didn't talk about this, but very briefly, can you tell people why or why not should you name your children that are children as minors as beneficiaries on accounts? Can you talk about that very briefly? Because I think we didn't touch on
Yes.
that, and it's important.
Yeah, it's so important. So in Delaware, the age is 21. If you were to have assets left to a minor, then there may be additional layers of protections in place for the minor if you haven't named a guardian or trustee over the funds for them or a custodian over the funds for them. So in a case where, for example, if you have kids and you pass away and your house by law passes to your kids without any adults being named as custodian or anyone else named as trustee or guardian. At that point, because they're minors, they can't consent to legal ownership, things that may need to be done with the property, like if there's a mortgage or if it needs to be sold or if they need to enter into an agreement for something, they can't do that. So without making other arrangements for them, in that case, the Chancery Court would need to be involved. A guardian would need to be appointed. And when I say guardian, not necessarily meaning the guardian who's physically taking care of the kids, although sometimes that's also needed, but a guardian over the funds for the child. And the court will need to be involved with the decisions related to the property, like if the house is going to be sold or if and if it will be sold, where's the money going to go? Often the court will demand that the funds are placed in trust until the kids reach the age of 21. So there are really important things to think about when naming kids. I usually recommend you don't want to name children for things. You want to name a custodian, or if you
Yeah.
do name the minors, if your account gives you the option to name the custodian if they were to inherit prior to reaching the age. So those are important things just because adding the court adds another layer, which could be really time consuming. And sometimes the court, because they're looking out for the best interests of the children and maximizing the funds that are going to be available for them, it really might not be what their caretaker needs, or it might not be what you would want for them. So it's important to do some extra planning while your kids are young.
Yeah, absolutely. And I think from here, we only have about 6 minutes till we're going to open it up for questions, because I know we have a few. So I'm going to skip ahead. I'm going to move through a few more slides that kind of get more specific about trust, and we're going to skip over to life insurance, because I do think this is an important discussion to have in relation to estate planning. All right, so sorry about this. We're skipping taxes. We're skipping a few credit shelter trusts and a few other things, but we're going to go on to life insurance. This is an important discussion for everyone to have. So just generally speaking, when I talk to people about life insurance, because we do offer, as part of a holistic financial plan, I am certified in life insurance as well as investments in finance. So I have the whole discussion with clients. There are two main types of life insurance. It's often a term-perm discussion. That's the way I like to remember it. So we've got term and permanent. Term life insurance is kind of like renting. Term life insurance tends to be cheaper. It's the type of life insurance that you're going to buy it to protect yourself or your family for a certain period of time. It's often what younger people purchase when they, like you might want to buy it. Like my husband and I have life insurance that extends until our children are finished with college. So that if something were to happen to me or my husband, whichever, it happens to, the other person would be able to have a couple of years to stay at home, hopefully, to not have to have the burden of childcare, and maybe some extra money for them to be able to go to college. So you're setting up for a certain period, but You're also not accumulating cash value. You pay month to month, relatively usually low fee, especially the younger you are you get it, the cheaper it is. If at any point the term insurance is not important anymore, you realize I don't need this protection anymore, whatever, if you stop paying it, the fund just goes away. The term insurance goes away. So in that way, that's how you're like a renter. You're also not accumulating cash value. It's not something that you own. The cash isn't going anywhere except for that protection. On the other side, you have permanent insurance. Now, permanent insurance, people often refer to this as whole life. They'll say it's either term or whole life. Whole life is actually a form of permanent insurance. There are a number of different types of permanent insurance that you can get. This is where, it's kind of important to have the discussion with a financial professional. But these are the types of insurance that are typically a little bit more expensive. They offer a death benefit, just like term insurance offers a death benefit. So if you pass away, the money goes to someone. But you can also actually access benefits of permanent life insurance often when you are living, because it accumulates cash value. And this is where I have that very important discussion. I won't get too much into it today, but with my clients about long-term care and how life insurance can be a vehicle. There are certain things you can attach to life insurance, things like that, to help provide for assisted living, long-term care at home, that type of thing. Some of those permanent policies allow you to actually be able to pull tax-free from that policy if you are determined to have a long-term care need. So we won't get too specific into that, but those are the two types of insurance. One thing about having life insurance, and Jacqueline has mentioned this, that a lot of times when someone passes away, funds are tied up for various reasons, right? One thing that life insurance can be very beneficial for, and kind of a breath of relief, is helping to pay for funeral expenses. Even the most basic life insurance. I often tell people to make sure they do the research into what their companies offer, what their jobs offer when it comes to life insurance, and then have a financial professional kind of evaluate from there. What are your true needs? What are the things that, if you were to die younger than you expect, what are the things that you would want covered for your children? What would you want for your spouse? What types of protections do you want in place? So that all kind of can be wrapped in an estate planning discussion. That is more on the financial professional side, but it's an important discussion to have. Get specific about what are the things that you would want taken care of when it comes to life insurance for your family if you were to unexpectedly pass. Okay, so we discussed term and permanent. So, Jacqueline, anything else on life insurance? I know we're at 12:45 before I touch briefly on the transfer on death, TOD.
No, you covered it all. We're good.
Okay, perfect. All right, so just very briefly, because people often want to know what a TOD is. If you work with someone at Edward Jones, like me, or you work with an investment advisor, you might be familiar with this, because most of my clients have TODs on file. Okay, so essentially what it can do, it's a specific type of thing that is offered that can avoid probate, reduce time to transfer certain investments, allows financial services to transfer account assets, does not apply to real estate, personal property, or assets. Essentially, you want to ask the financial professional, if you're talking about a financial account, you want to ask if you're able to do a transfer on death. It does supersede the will or the trust for assets. What I normally tell people is what happens is if I get a notification, or, regardless of how it happens, someone has passed away, all I need is proof of passing. And from that point forward, if there's a transfer on death available, opening the accounts for the beneficiaries, money transfers in. It's just that quick. It's a way you can avoid probate, and it's a way that you can ensure that the money that you have in your investment accounts and your financial accounts transfers quickly. Jacqueline, anything else you want to add on that before we take questions?
No, so transfer on death is just it's a good tool to use to avoid probate to make the funds available sooner. There is just the caveat that even if you do have transfer on death designee, those funds may still need to be used to pay for certain expenses of the estate. So,
Yeah, good point.
and you know, you do need to keep all that in mind when planning to figure out the best way to leave the funds.
Perfect. Perfect.
Are
Yeah,
you ready
thank
for
you for that.
questions?
I forgot. Yeah, let's do it. We managed to make it. Normally we do run quite a bit over, but we spoke fast. We whipped through it. So let's take our questions.
Okay, so
We
we
can go
have,
on all day here.
yeah, we have a lot of questions. One of the biggest ones is executor questions. So I'm going to read them and then you guys probably can summarize them in one answer. So the first one, or just give a yes or no. Can your beneficiary also be the executor?
Yes.
Okay, great. Can an executor create a trust for a deceased loved one's minor children if they didn't make one?
Ooh. Um,
Boy, that's a good one.
so typically, if you, so there are different ways to leave as. So if you have a will and you say, for example, I leave my assets to my 3 children in equal shares per Sturpes. That would mean that if one of your children passed away and they had kids, their share would pass to their kids. Like think of it as the family tree with 3 branches and each 1/3 would continue. If there was a situation where your child passed, then and then you had the grandkids, and the funds would pass to the grandkids, but they were minors, your will should also have a section that would designate your executor, your personal representative, to be able to make arrangements as the custodian for the minors until they reached an age. And so, if the will included that information, then the executor could make sure that everything was set up correctly for them without having to involve the court. So that's where having a good will comes in really important cases here.
Awesome, thank you. When someone passes and they have named an executor, is there a way to gain access to the information in the document once this person has passed? I'm assuming this is someone who is not an executor. Can they have access to the document?
So once a will is presented for probate with the Register of Wills office, you can go to the Register of Wills to request a copy of the documents that are filed. So they do charge a fee per page, but it's reasonable. And that's how you would be able to get access to that.
Okay, awesome, thank you. Can you add someone as a joint owner who you're not married to, like a significant other, I think that stands for, or children?
Yeah, I'll take, at least on the finance side, I will take that yes, there are certain things that change within the estate process. If it's a joint, we often have joint accounts with rights of survivorship here, which doesn't necessarily mean it has to be a spouse. But there are certain things that change. You kind of want to have a discussion about what does the account look like if one person passes and they're not spouses, because it can have tax implications and other things. But yes, you are able to do
Awesome, thank you. What happens if you die and your immediate family doesn't know whether or not you have a will?
that.
That's a tough one.
Yeah.
So when you make a will, I always advise clients that they should talk to their family about it, about what's in it, if they have questions. So this way they can, again, not to have surprises down the road. And also so that the people who are named as executors, your primary and your backup, they should know exactly where your documents are at all times. So that's an important piece. Sometimes there are situations where, mom might say, yeah, I did my will, but never gave anyone a copy, never told them where they are. And then, the kids might contact lawyers who mom may have contacted, or we may put out an ad in the bar journal that goes out to all the lawyers saying there's a lost will. If anyone has a will for this person, please contact us, because that's really hard. If the will is not found, or if there's no evidence that a will was ever created, then we're going to have to go with what the statute says in terms of the intestacy succession.
Okay. Um, what are some things to consider or discuss while writing your will when you are a business owner?
Yeah, that's an interesting one. And could be, to be honest, a whole separate discussion. But thinking about how you want the transfer of business to happen. A lot of that just kind of involves your business succession plan, which really should be a separate document actually to your will. I mean, you can refer to it in your will, but I recommend that business owners do have a separate business succession plan. So I'll briefly answer it that way because we could really get into it a lot. Of course, taxes are one thing to think about. Do you want to sell your business to someone while you're living? Is your business part of your retirement plan? Or is it something that you are looking to pass on to your heirs in a certain way? There are a lot of tax implications that change in those decisions. So definitely you want to talk to a financial strategist and a tax accountant about that, as well as an estate attorney. That's kind of like the holy triangle there for business owners.
Wonderful. Now, there are more questions, but before that, we've had several requests for you both to share your contact information, if you'd be willing to put that in the chat, your email, and how to reach out
Oh,
to you,
sure.
um, as well as requests for the slides. That's up to you, Lizzie.
Unfortunately, I can't release the slides legally because Edward Jones will not let me do that. I will say there are some extra documents if anyone is interested. Normally, when I do this in person, there's an estate planning organizer tool that I give to people. Jacqueline has seen it as well. It's a really good kind of all-in-one for making sure you're prepared. And it's a document that I say fill it out and leave it by all your important documents. So if anyone wants a copy of that, they can either stop by my office or I can actually attach and send that. So that is something I can offer.
All right, this one is having an account to reflect POD as good as having a beneficiary? Are there different tax benefits?
It really depends on the type of account. So typically, a beneficiary designation is better than having a transfer on death designation because of what I mentioned with probate and how transfer on death designation may still require funds to be used for paying expenses related to the estate, whereas with a beneficiary designation, you wouldn't have that concern. Um, as far as taxes go, I can't think of anything off the top of my head where the taxes may be different, but I do know, like, for example, with retirement funds, usually for retirement funds, you would name a beneficiary, and then, like, if it's an IRA and there's a spend down period, that would be handled through the account, and you wouldn't, for that type of account, you just wouldn't use a transfer on death designation. They would use the beneficiary designation.
Right.
So I think it's more of the practical way the funds would transfer as opposed to the tax consideration for that.
Yeah, and I would say as much as possible, and this can summarize a lot of this, is speaking with an estate attorney and a financial professional so that you feel like you kind of have you have everything under the correct umbrella. IRAs, for example, 401ks and IRAs, they have their own rules necessarily related to spouses, related to kids in terms of tax and other implications. Everything is going to have, kind of its own set of rules. We've given you a very basic idea today that will hopefully inspire you to contact one of us or at the very least have discussions. But I would say, when you get into these discussions of is one better than the other, the only real way you'll be able to determine that is to talk to a professional and an estate attorney, for sure.
Lizzie and Jacqueline, just really thank you for your time. I hope everybody, actually, I can tell by the comments that everyone got a lot out of it. So you guys are amazing. Thank you for attending. And I will send that information out.